us to start our meeting. My name is Wojciech Cyrul, and I will have the pleasure and honor to moderate today's meeting and this scientific panel during the day. We have presented three speeches for today. We have three distinguished speakers, one from Poland, Dr. Michał Araszkiewicz, and two speakers from Portugal, Pedro Venâncio, who is a professor at the Polytechnic of Porto, and João Vieira dos Santos, who is a legal advisor at the Portuguese Securities Market Commission. I hope all the speakers are already with us and will have no technical problems with transmission of the with video transmission. I believe that everybody who wanted to be with us is already registered and can participate in the meeting. So not to prolong, I will give the floor to Dr. Michał Araszkiewicz, who will speak today about the frame-based theory of legal content communication. Well, Michał, the floor is yours, and I wish you a very good presentation.
Thank you very much, Wojciech. So first of all, good morning, good afternoon. I would like to congratulate the organizers of this fascinating event for already great success. I think it's very important to bring together researchers from different countries and share ideas and research results, and to join the theoretical and practical perspective. And in my opinion, this event satisfies this goal simply perfectly. It's fascinating. I already learned a lot yesterday, and I do hope to learn more, even more today. So let's begin with the presentation. I will be happy to share the screen. Is my screen visible?
Yes, I believe it is.
Okay, that is great. So, as our chairman has already mentioned, this talk is titled "A Frame-Based Theory of Legal Content Communication." I believe that my research is perhaps not known to the majority of our audience, I will be happy to begin with a short introduction concerning the perspective I am coming from and I am working within. So I am an adjunct lecturer at the Department of Legal Theory at the Jagiellonian University. I have a PhD degree in law. My area of specialization is AI and law. This is the scientific community in which I've been involved for more than 10 years now. I'm happy to participate in the community. So in particular, I serve on the executive committee of International Association for Artificial Intelligence and Law, which is an international association incorporated in the United States, as well as in the steering committee of the European URIX Foundation for Legal Knowledge and Information System. I had the pleasure, for instance, to be the URIX program chair 2 years ago, and I'm happy to co-organize a series of XILA workshops, Explainable and Responsible Artificial Intelligence and Law, 4 editions organized so far, the present year's edition forthcoming. In addition to research activities, I'm an attorney at law, where I specialize in intellectual property and new technologies. And I also serve on the steering committee of the council of our district bar association, where we are also very concerned about the legal tech and the technological support for attorneys, for legal advisors. All right, let's go directly to the presentation. So this presentation was prepared in a frame of the research project titled Legislative Errors and Comprehensibility of Legal Text, which is chaired by Professor Krzysztof Płeszka from our department. Professor Wojciech Cyrul is also in the scientific committee of this or the scientific group of this project. So this is an interdisciplinary project when we are integrating the insights from legal theory, legal practice, and also computer science in order to foster the detection of legislative errors in legislative texts. So what is in the background here is that traditionally there is a question concerning how we are going from the natural language expressions which are to be found in legal text to whatever is called legal norms. Of course, the very concept of legal norm is very disputable. The standard answer is that this purpose is being achieved via interpretation. Interpretation is again a very disputable concept here. Recently, the process of interpretation is typically modeled as argumentation, and we have numerous computational models of argumentation, which is a very promising direction of research. But the question is, how should the content of law and also the content of other premises that are used in interpretative argumentation be represented? I hope that I'm still audible because we have stormy weather here and this may also be audible, but I believe that we can't do anything about it. So the topic of formal representation of legislation has a very rich history already, beginning with the early attempts to model legislation via first order logic already in 1960s, 70s, then predicate logic, different calculi of deontic logic. Then from 1990s on, the legislation was typically represented via the different systems of divisible rules and non-monotonic logic. And also in 1990s, the frame-based representation was initiated. What is a frame? The frame is the concept that was introduced to the knowledge representation theory by Marvin Minsky in 1970s. A frame may be understood as a collection of slots which represent certain features of an object, and these features are represented of values of certain parameters. So I will present an example soon. So during the late 1990s and then in the 21st century, the frame-based representation of knowledge has become one of the important components of thinking of representation of information and data in semantic web technology, about which Professor Wojciech Cyrul has presented already yesterday. As far as the present research is concerned, the content of legislation is also being presented mathematically, for instance, as n-dimensional vectors, which is a representation suitable for machine learning-based natural language processing models. So the frame-based representation of knowledge is being taken into account by the theorists of communication, and here we are taking into account the theory of communication, which was developed by a Polish psychologist and communication theorist specialist Marek Tokarz, which is basically a frame-based theory. According to him, communication consists in filling in the slots of frames, the frames that represent different situations. This may be real-life situations, this may be hypothetical situations, or postulated situations. So, for instance, if someone sees an elephant running and says, "Elephant is running," the following frame is being filled by the recipients of this communicate. So we have a slot for an agent. In this example, it's an elephant. This agent is performing a certain activity. It is running. We have this activity is localized. So here we assume that this elephant is running somewhere in the range of sight of the observers. However, in fact, the situation may be different. So it is also possible that this elephant is visible on the screen of the television, or it is just like a hypothetical situation someone is trying to refer to. And if the intention of the speaker is that this speech act is a descriptive act, is an assertion, then also the stages slot is being filled in. And here the stages of this descriptive sentence is presumably true. Of course, it may be contested. So here, of course, this is a very, very basic introduction into this theory of communication, but I think that these basic ideas are already very visible from this basic presentation. Marek Tokarz applies his theory of communication to very different domains of application, especially to everyday communication. In everyday communication, we typically formulate very anthematic phrases, which means that important parts of our communication are being generated or reconstructed by the recipients of our communicate. This theory is particularly useful because it explains many mechanisms of misunderstanding, the working of the so-called conversational implicatures. Of course, this theory may be also applied to model questions and commands, but not only simple statements, but also the processes when we are chaining the statements together, both in informal reasoning, analogy-based and persuasive argumentation, but also in predicate logic-based reasoning. So the domains of application of this general communication theory is quite broad. So it is quite natural and very tempting to assume that this theory may also be fruitfully applied to a very specific area of communication, which is the communication between the lawmaker on the one hand and the addressees of legal regulation on the other hand. Not to mention, of course, the law applying authorities. So we intend to represent legal text as a collection of frames which specify agents that are referred to in legislative texts. This may be agents responsible for performing certain actions and the counterparts, that is the recipients of these actions, the actions themselves, objects of actions, different modi of actions such as temporal, spatial, or adverbial, and of course also deontic modalities. So the content of legal text, may be represented in such frames, and this representation does not only consist in paraphrasing the natural language expression. Each paraphrase of the natural language expression, of course, involves resolving syntactic ambiguities, which is already a very far-reaching operation. But also in the process of concatenation. The process of concatenation means that we are taking into account more than one provision, and we are reconstructing one frame on the basis of 2, 3, 4, or a greater number of legal provisions. Completion. So in the process of completion, we are adding information which is not explicit in the text. So we are simulating the process of reading of this legal text by a legal professional. And legal professionals read legal text in a specific manner, which is available for them due to specific knowledge structures which they acquire during the legal education and practical experience. We, of course, also need to resolve semantic ambiguities, in particular concerning the scope of the concepts that are used in the representation, and this part is particularly interesting for us. So this approach enables us to identify quite clearly some problems concerning understanding of legal text. For instance, we may have some problems related to understanding of legal text if the text itself, when read by a legal professional, gives no grounds for a minimally complete reconstruction of the frame. This means that, for instance, an agent is missing, or the action to be performed by this agent is missing, or certain modi, like for instance temporal modi for the performance of this activity is missing. And this may be referred to as situation of a legal gap, of course, of certain type, because the very notion of legal gap is very ambiguous and debatable in legal theory. Then it may happen that concatenation of the frames representing different provisions may reveal incompatible information, and in this respect, we speak about contradictions in legal system. Finally, and here we are touching upon a particularly fascinating problem, different readers of legal text, so different addressees of the communication that the lawmaker is directing toward us, may have different ideas concerning completing of the slots of the frame. So even if we agree that a certain slot of a frame should be completed in certain manner, we may still disagree about the precise completion. So technically speaking, the value of a parameter that should be put in the particular slot of the frame. And in this connection, we may represent different interpretive hypotheses which concern interpretation of statutes. What is important here is that revealing of these different interpretive hypotheses may be the result of the process of concatenation. So if we are taking into account the different provisions, they may affect the interpretation of each single provision. So in this frame-based representation of statutes, we represent different interpretation of legal text, which can have different grounds. I believe that the types of legal interpretive arguments, well, we know that they are quite similar in different legal cultures, even if, of course, they are different in applications, but as far as the catalog of these interpretive arguments are concerned, these catalogs are quite similar in different legal systems. We concede that there does not exist this knowledge-based interpretation of text as such. We always represent a certain interpretation of a legal text. And here we have an example. We are not going to analyze this in detail. This is just to give a glimpse how this knowledge base is prepared. So we begin with like manual representation of the content of legal provisions in similar tables, where we refer to the number of the provision, the type of interpretation we are intending to represent, the provision type, which is very important slot, the deontic modality, and then we identify subject agents and whatever other slots that are necessary to represent the content of this legislation. Here we have an example from the Polish pharmaceutical law. This is, of course, just an example. But this is only a first step, because in the frame of this research project, we are actually implementing this representation in semantic web technology, together with my colleagues Tomasz Żurek and Enrico Francesconi. We have already prepared some modeling basing on the earlier provision model, and so we are using the OWL language and RDF representation to represent the legislation and to enable Sparkle queries, which lead to the possibility of automated identification of potential errors in the legislative text. So we are of the opinion that this type of modeling is an important step towards machine consumable legislation, because once it is put in the OWL language, it is already machine readable. On the practical layer, it helps detecting errors such as legal gaps, contradictions, redundancies, excessive ambiguities, and so on and so forth. But it also enables us, we think, to understand better the mechanisms of legal interpretation, at which, to the extent this process is intersubjectively communicable. At this moment, I would be very happy to take an advantage to invite all participants of this great event to take part also in the 18th International Conference on Artificial Intelligence and Law, which is going to begin in 9 days from now, starting June 21. It is actually organized by the University of Sao Paulo in Brazil, by my great friend Juliano Maranhão. Well, I'm happy to be involved in the organization of this conference on the as the member of the executive committee of our association. The registration for this event is free. There will be main conference and I think the 9 workshops. You are cordially invited to participate. Thank you very much for your kind attention.
Thank you, Michael. It was a really interesting and fascinating presentation. You were talking about quite complicated things and issues in a very, very good way. So thank you very much. But because the time is running, I will now give floor to Professor Pedro Diaz Venâncio, who is with us and will speak about the copyright as the last stronghold for freedom of expression. I believe that you know Professor Diaz Venâncio also from his publication on the Information Society, but today he will speak about copyright. So please, Pedro, the floor is yours.
Okay, thank you very much for a short presentation. I'm very happy to be here. First of all, I would like to apologize the first speaker for being late a few minutes and therefore missing the beginning of his presentation. I will also like to inform that I'm presenting from home, so there might be some noise during my presentation because I have a contractor doing some work around home and also 2 dogs that like to participate in my conference. So I'll hope everything will go okay. I'll try to share here my presentation. Let me see. And okay, so hopefully everyone is seeing the presentation now. So
yes,
yes, my topic is copyright, the last stronghold for freedom of expression. Is actually a working topic for me. I'm still gathering information on this topic, and I'll try to present today my first 3 main conclusions, and hopefully the audience will give me some more information I can use for my investigation. So the topic starts by freedom of expression. Freedom of expression and the relation between freedom of expression and freedom of creation. If you look to the Declaration of Human Rights, the Universal Declaration of Human Rights, Article 19, you see that the freedom of opinion and expression is protected through any media, regardless the media or the form is that you use to express your opinion. And actually, inside the Declaration of Human Rights, you can relate this Article 19 also with Article 27. Article 27 established the right to freely participate in cultural life. So freedom of opinion and freedom of expression, in my interpretation of these two articles, it relates also to the freely participate in cultural life. And actually, this same Article 27 in name number 2 expressly says that this freedom of participating in cultural life includes the protection of literary and artistic production, and therefore the protection by copyright, we might say. So this established a first connection between freedom of expression, freedom of creation, and copyright as something that relates to human rights. So the first conclusion on this reflection is this idea that the freedom of creation cannot exist without freedom of expression. Freedom of creation is a part of freedom of expression. It cannot come one without the other, or at least you can have at least freedom of creation without freedom of expression cannot be fully I'm missing the English word for that, but you cannot obtain a total freedom of creation without freedom of expression. That's what I meant. If you go inside Portuguese legislation, in Portuguese legislation, you have in Article 37 also the right of freedom of expression. But what happens is in Portugal, this same right says that this freedom of expression cannot be limited by any form of censorship. And this is where I will try to go further on. Can it be censorship to copyright or not? That's the point I want to get to. So, but the idea is freedom of expression is the freedom of disseminate your thoughts without any censorship from the state or anyone else. And also in the Portuguese constitution, you have the same relation between freedom of expression and freedom of creation. In Article 42, you have inside the many fundamental rights that Portuguese constitution establishes, the freedom of intellectual, artistic, and scientific creation. And here you have a direct link between that and the protection by copyright. Copyright protects the free creation, intellectual and artistic creation, and the free intellectual artistic creation needs freedom of expression to be fully accomplished. Of course, you can say that freedom of expression and even freedom of creation doesn't need copyright. You can have freedom of expression without copyright. Yes, that is true. The thing is whether copyright promotes or not freedom of expression. If copyright, it is a legal form able to protect freedom of expression when it exists. So we can here conclude that freedom of expression, like I said, precedes and does not need copyright. But what I try to establish in this study, what I'm trying to establish in this study, like I said, is not yet finished, is that copyright protection promotes freedom of creation and protects freedom of creation. And by doing so, also promotes and protects freedom of expression as a more broad fundamental right. So the second step, the second conclusion is that we can establish the following relationship. First, a relationship between freedom of expression and freedom of creation, and a second relation between protection by copyright and freedom of creation. So if freedom of creation is a form of expression and copyright protects freedom of creation, the issue is it will also protect freedom of expression. If you look to the Berne Convention, which is the main international treaty on copyright, however, you will see that Article 17 predicts censorship over copyright, because Article 17 of Berne Convention establishes that the right of governments to control or prohibit by legislation or regulation any content in copyright, protected by copyright. So, but the Berne Convention predicts the possibility that states can actually censorship creations protected under copyright. And although the Portuguese copyright code does not predict any way of prohibiting or censorship over copyright works, in fact, it also doesn't say it cannot be done. And it can be done, and it has been done in Portugal several times. It has been admitted that a work can be prohibited to be published if it is offensive to fundamental values of state, for instance. In the case of Portugal, it is prohibited to publish works that promote fascist regimes, for instance. It's in the constitution, and so works can be prohibited by that. It can be prohibited to be published. It's also understood that some works can be prohibited if they are against public morals. That is not that common in Portugal. Being a Catholic country, it makes very moral is very broad and intended. So, but there are other countries where you find many works that are prohibited because of public morals. You know, prohibit. You have experience of works that are prohibited to be exposed because they have nudity. Films that are prohibited to be seen in cinemas because they are violent or because they have pornography or whatever. They have been. You have all around the world many examples of works that are prohibited to be published or to be seen because they offend public morals or what is intended by that country as a public moral. And finally, you can also, some works can be prohibited because they offend the honor of a particular person, if they consider to be offensive to someone and in an unfair way, they can also be prohibited. So censorship in copyright, even in what we may call the democratic countries, is not something that doesn't happen. It happens all around the world in all the countries. In some happens more than others, but in all countries, they have some sort of censorship. And I don't mean here censorship as something with any political intent, as something that the idea of censorship is here is just prohibiting some work to be published because it offends something. It offends some value of the state, it offends some public moral, or it offends fundamental rights of another person, for instance, his honor. But even when you have works that may be censorship by some of these values because they offend some of these values, within copyright, you have some parts of copyright where courts have considered a more broad sense of freedom of expression. If you look at satirical and critical works, usually it has been understood that they can be more offensive or they can more freely go over issues that traditionally are considered morally inadequate or something like that. So even recently, Portugal has published a very controversial law on human rights in the digital era, where it established some measures against disinformation that has been very controversial in Portugal. And even that law established that measures against disinformation does not apply to satires and parodies, as considering that in this kind of work, the freedom of expression is more broad. It can be more freely appreciated. So the question that the final question that I want to make here is, okay, let's say that some state, for some legally valid reason, prohibits some work to be published. Does that mean there is no copyright? If some work offends the values of the state, if some work offends, it's immoral, if some work is against the honor of someone, does that mean that the author doesn't have copyright over that work? Does it mean they cannot? It means he cannot publish it, that's for sure. But does it mean there are no copyrights? What's the consequence of that? The Portuguese doctrine is consistent with the idea that even though the work may be prohibited to be published or to be seen, copyright exists. Because the only requirement for copyright protection is that it is an intellectual creation with originality. So if you have an intellectual creation with originality, it is protected by copyright. If it can be publicly published or not, that's another issue. So for the Portuguese doctrine, the main Portuguese doctrine, a work that is prohibited by law, nevertheless, is protected by copyright. And here is the point where I think that copyright may represent an extraordinary protection for freedom of expression. And why is that? Well, because work is prohibited, is still protected, then we can take out of this several consequences. The first of all is that it's protected because it depends only on the act of intellectual creation. And therefore, the act of intellectual creation still gives the author the ownership of the creation. So it still is recognized as the author of that creation. And the second issue is that since the intellectual work is immaterial and therefore is perennial, it persists, intellectual works survive survives time, survives politics, survives political wills, and goes beyond frontiers. There is no frontiers for any material work. And because of that, the work may survive the political will to prohibit. It may survive the law that prohibits. So perhaps today the work is illegal, but perhaps tomorrow it's not. Perhaps it is illegal in Portugal, but it's not illegal in Poland. And that means the work survives. And therefore, freedom of expression survives. So that means that the author of a prohibited work can still publish it in another country. So if I have a book and that book is prohibited to be published in Portugal, I can still publish it in Poland, because I still am recognized as an author in Poland. And if in Poland it is not illegal to publish it, I can publish it there. Some films are prohibited in some countries and they are not prohibited in others. Second, I can oppose myself, I can oppose others to use it. Although it is illegal to publish, doesn't mean that I don't have moral rights over it. So I can refuse others to use it, or to modify it, or to use it in a way that I don't agree. So they cannot clean my opinion from my work. They can prohibit to publish that, but they cannot take away my opinion from that work, because they still need my authorization to change it. Let's say that I have a romance that is prohibited and someone wants to make a film of it. I can refuse to adapt the adaptation to a film if they take out the scenes that are prohibited, because I think that without those parts, it's not my work. So I preserve my opinion, and I can legally preserve my opinion against the will of others. Which means that I can use my, I can still use all the moral rights that come with copyright, regardless the fact that it is prohibited to publish the work. And finally, and this is not here, sorry. And finally, since like I said before, since copyright protects the work for the period of, nowadays in Europe is in European Union is 70 years after that, probably the work will survive the law. Probably the law that prohibits that work will change, and copyright will still persist, and I can still publish. We have in Portugal dozens of works that were prohibited before 75 and now are published. So there are several countries that change the political regime, and they, in the previous political regime, they have works that were forbidden, and now they are free to use. Copyright persists. Besides, it goes on and stays. So this work, so my idea with here is to establish these three main ideas and to make some points with these three ideas. The first idea is that freedom of creation is an expression of freedom of expression. That doesn't sound very well written that way. Okay, I have to change the sentence. So that's the first idea. No, copyright. The second idea is that copyright promotes freedom of expression. While protecting freedom of creation, copyright promotes freedom of expression. And the third idea is because copyright protects intellectual property that knows no boundaries, whether in territory, whether in time, that means that even though a work can be prohibited in some place during some time, copyright will persist outside that place and outside that time. And that means that the work and the free expression that it represents will continue around the world whenever, wherever, and whenever it's not prohibited to publish. And so copyright represents, in this sense, a certain stronghold of freedom of expression, a zone where freedom of expression is more broad than in any other place in a legal regime. And this is my very short presentation. I hope I can count with some comments on the part of the public that may help me to have more density in these ideas. And thank you very much for your attention. And I finish here my presentation.
Pedro, thank you very, very much for your very interesting insight into copyright and the freedom of expression, freedom of creation. I believe there will be a lot of questions. If not, I will ask myself even. But I hope that the audience should have the right to intervene first. So thank you very much once more. Now we have the last speaker and the last presentation for the session. Our guest is João Vieira dos Santos, who will speak about the Fintech regulations and the digital finance package. João, please, the floor is yours.
Thank you for the floor. Firstly, I would like to greet everybody, greet the public, good morning or good afternoon. Greet also the moderator and my colleagues of the panel, and I would like also to congratulate them for the fantastic and very interesting presentation that they give us. About my topic is Fintech and digital finance package, the package that was presented by the European Commission September last year, that has an action plan and free proposals of regulation. But firstly, about Fintech regulation. I don't have here a PowerPoint presentation, but I would like to present some ideas about this topic. And if you have any reactions, any comments, or any questions, please, it would be great to share and to have a dynamic about this topic and about what you think about it. Firstly, about Fintech regulation. Normally, we see a lot of approaches that are uniform regarding Fintech. But what I realize is that we have many models in Fintech, many categories that must be considered in different ways in order to have an approach, a regulatory approach to them, and to fit them in properly in our legal framework. In my view, we can divide it in three main categories. The first being the Fintech that represents different business models, but don't represent any emerging technology. There are many business models in Fintech that only are structured only in internet, for instance, and we cannot consider that an emerging technology. Everything now, mainly in finance, it's everything in internet. So we cannot say that some business model that is in internet is innovative per se, but there are some different models that are trying to innovate in internet and in another technologies that are already spread between also the incumbents, the financial entities that are already established. Those this first category is composed by business models, for instance, crowdfunding, that competes with the incumbents. So it's important to have a legal structure that balances them and that creates here a framework for the relationship between them and the incumbents. The second category, I would say, that would be the fintechs that are supporting the incumbents with emerging technologies. We have emerging technologies, but the business model is not new, or is only supporting the business models of the incumbents. For instance, RegTech and SubTech companies. With RegTech, I mean companies that that support technologically the compliance of incumbents of the law, of the financial regulation, helping them with the onboarding regulation, so the KYC, helping them with the reporting, and with many aspects of financial compliance that in the recent years have increased a lot after the financial crisis of 2008. The compliance is stricter, and so these companies are trying to reach that need that now financial entities have. And at last, at the third category, we have fintechs that are based on emerging technologies such as artificial intelligence, big data, blockchain, so DLT in general, distributed ledger technologies, such as crypto assets and business models related to crypto assets. And in that sense, they are the truly disruptive business models. We have business models that are new, and they are based in emerging technologies. So here we have three categories, and that we need to see them differently, because only the first and the third are going to have a need for a regulatory framework for them, because the second, that is only supporting incumbents, it's attached to the legal framework of the incumbents. Only the ones that are trying to innovate in the business model, or trying to business model and using emerging technologies in business models, are the ones that we need to try to find a space for them in our legal framework. Because of that, and because to fill the space is not very easy, there are a lot of approaches from financial regulators and also legislators. There are some general approaches like soft law, like trying to alert investors to these new risks that emerge from these new business models and emerging technologies. There are also innovation hubs that are being created from the regulators, from the financial regulators, trying to give a space of communication, of close communication between these innovators and the regulators, and at last the regulatory sandboxes for experimentation and experimentation if these emerging technologies can work with a legal framework, and what must be amended, so a space that we can have a safe environment, and we can see if there is a need of amendments in the law to foster innovation and to give space to this new innovation, to the new innovation and innovative business models. We have these two different approaches and also new proposals, new legislation that is trying to emerge from the European Commission mainly. There are some countries that are advancing in this new digital finance framework also. We see Estonia and Malta, for instance, that they are trying to be the first to have a legal framework about these new innovation models. Also France, with the Macron administration, is paying attention to this. But speaking broadly about the European Union, we see, for instance, that the European Union already started to have a lot of attention and a close approach to this in 2018. In March in 2018, the first Fintech action plan started. And with that, it started also the proposal for crowdfunding regulation that finished not long ago, and on October 2020. And the approach is it's very interesting from the European Commission, because the difficulties here are to have a level playing field, not to benefit a lot the innovators in detriment of the incumbents. There is some protection that we need to give to them. Also, technological neutrality is not only because you are using a technology that you are going to have different rules. Some rules apply independently, regardless of the technology used, and must be that way. But also there is a need to foster innovation, and in the competitive world, like global world like we have today, there is a lot of competition between China, United States, and Europe, mainly in the technology sector, and so it cannot be a difficult framework for the innovators. It must be also simple and practical, and that, like I said, give all the protections for the consumers and the investors, because only with a legal framework that is apprehensible and that is comprehensible to every actor, every player, only that way it would be easier to the innovators to act in Europe. In this way, the regulation of crowdfunding tried to to find the right balance between these objectives that I told you. They try to copy many of the obligations that we have in MiFID, for instance, the Markets in Financial Instruments Directive, trying to give some protection to the consumers because of the risks that are involved in crowdfunding that are very similar also to the risks that we have in the markets of financial instruments. In that sense, some of the crowdfunding platforms have rules like the financial intermediators, but with a light approach, with a not so heavy requirements as the ones of financial intermediators, with the goal of having this fostering innovation, to foster innovation. About the digital finance package, arriving to the digital finance package after the Juncker mandate, we have a new mandate in the European Commission, and it also started with the presentation of a new digital finance package that has a new action plan for fintech, and also the three proposals of regulation that I already told you, and that I'm going now to detail. The first one about cyber resilience, the second one about crypto assets, and the third one about the DLT pilot regime. I'm going to base the later two, because of the crypto assets, telling you that this approach of the European Commission with crowdfunding was here reproduced. We have an approach that is based on the financial regulation about the MiFID and also other regulations of the financial EU law, like the prospectus regulation, the payment service directive, where we see that the crypto assets, and this was the approach from the European Commission. We see that they are only digital representations on a DLT, but they can represent a lot of instruments that are financial, that resembles a lot currency, that resembles a lot financial instruments. And so the approach was to give a legal framework that is very proximate to them, but it's a bit lighter, with the objective of having innovation in the European Union. So the approach is the same. It's interesting to see the European Commission trying to reach the right balance between all the protection that we need, financial stability, level playing field with incumbents, protection for the consumers and the investors, and also to have this fostering of innovation and trying to help innovators to be legally compliant. Also would like to talk a little bit, just to finish, about the DLT pilot regime. That is a regulatory sandbox. It's an experimentation for the use of DLT, of distributed ledger technologies, being the most famous one, blockchain, in markets infrastructures like in central securities depositories and in MTFs, multi-trading facilities, for the trading and settlement of securities. And this is an interesting approach. We never saw a regulatory sandbox in the European level, in the European Union law, and it's interesting to see this approach. And it would be interesting to see this being used in more technologies, and also in a more general way. We already see regulatory sandboxes used by member states in a general way, a regulatory sandbox to everyone that has an innovative business model. And it will be interesting to have harmonization in this level, because we see very different approaches from member states. We see member states that don't amend anything from the European law and try to give some exemptions in their national law. But we see the member states that are using, are amending and are excluding the sandboxes from the European law scope, because they say that in the experimentation, in the tests that we have in the sandbox, the financial entities are not acting professionally. One understanding that is very dubious, but we are seeing some member states advancing with this perspective, and so in this way they are exempting every norm, European law norm that would be applicable to a financial entity in normal terms, and so are experimenting in a large spectrum. In this way, it will be interesting to have European Commission, the European institutions, to have an understanding about this and to advance with the sandbox that it's has a bigger perspective and that can be used by all innovators. In this sense, it was my 2 cents to this topic that has a lot of things to be said. So I'm open to discuss any doubt that you have. So thank you very much.
João, thank you very, very much for this presentation and giving us such a wonderful insight in this complicated world of fintech and finances and how it's regulated, and what are the major problems currently in this field. Now we have quite a lot of time for discussion. I thank you all of the speakers to limit their presentation and be on time. So we have almost 1 hour for questioning and answering. I saw already quite some questions on the to the authors. So I will give floor to our audience, and please start asking questions.
Hi, Professor. We received 2 questions at the chat. If you prefer, we can read it for the professors could answer. I don't know.
Well, just please ask questions, and I think that the speakers will be answering directly after the questions. Well, there are already on the messenger. I see some question to all of you. I don't know why participants, the audience, the members of the audience are not willing to ask them publicly. So maybe they are a bit shy. But please do ask questions openly and publicly. I think that our speakers will be very willing to answer them. If you have any comments, also please do it publicly on the chat. All right, so maybe I will ask first question, and it will encourage our audience to ask another questions. I have a question to Professor Pedro Diaz Venâncio. Well, I very much like your approach. It's a very insightful and very interesting argument. But how you would address such an argument? It's a very old principle coming even probably from Roman law, that law should not protect lawlessness. Yes, and in fact, many legal systems, also in the American legal system, illegal or lawless activities are not protected. Would you agree that your approach actually is contradictory to this very old principle of law?
Let's see if I understand. Okay, let's see if I understood the question. The issue is that law should not regulate something that is not legally relevant.
No,
No.
The law should not protect lawlessness.
Okay.
So it means something what is illegal or lawless should not be protected, or it's not protected. In many legal systems, such a principle is usually presented even on the constitutional level.
Mm-hmm. Well, yes, I think that at least in the form that the Convention of Bern is presented, it has a certain it has some contradiction in there, but in fact the Convention of Bern gives the countries the possibility of prohibiting and therefore not allowing certain activities that they don't consider proper, and doesn't give any idea which ideas they should be. But what I think, and relating that issue with one issue that was put in the discussion panel in writing, that is the relation between this protection of copyright, of the liberty of expression, and the problem of misinformation. The thing is, freedom of expression, making freedom of expression dependent on the veracity of information is a problem, because the veracity of information truth is contextual. When Galileo said that the earth was round, it was misinformation at that time, because the scientific truth at that time was the earth was not round. Should it be prohibited to publish that opinion? Is that good that it is prohibited to publish that opinion? Look, when I start as a lawyer many years ago, my patron in law said to me once that, and I never forgot that, he said to me, all judgment has 4 truths. 4. One is the truth of the plaintiff, the another is the truth of the defendant, the other is the truth that the judge finds out in judgment, and finally what really happened. And so making freedom of expression dependent on something that does not exist, truth does not exist, that's one problem. The other problem is that there is very common expression, everyone knows that, I don't know the right translation to English, but is being wrong is human. I don't know how to say that in English correctly. Errar é humano. I don't know if someone Portuguese speaking can help me how to translate that to English. I'm not sure. But the thing is, freedom of expression is the right to be wrong. If you don't have the right to be wrong, you're not free. And what I'm saying is, copyright protects every intellectual creation that has originality, regardless of merit. That's what the Convention of Bern said. Regardless of merit, it can be good or bad. Regardless of quality, it can be very good, a very good quality of the worst quality in the world. So it doesn't matter if it's a good song or if it's the worst singer in the world is still protected, regardless of its aesthetic, if it's beautiful or ugly, and regardless of its ethic. So a work that protects charity has the same copyright that a work that protects, that encourage hate. For copyright is the same, and that's why it protects freedom. Because if you don't have the right to be wrong, what right do you have? What's freedom if you cannot be wrong? That's my issue. I don't know if I answered your question.
Well, I don't want to monopolize the meeting. On the chat, there are another questions. I see a question to Michał. Could you please answer or comment on the problem of dialogical or argumentative models?
Yes, so I have already answered briefly that indeed this is a standard approach nowadays. However, I would like to go a little bit deeper into this. Generally speaking, there is an earlier approach according to which the slots in these frames could be generated on the basis of the chain of inference, which is in fact monological. This was an earlier approach based rather on symbolic logic, and nowadays it is considered a bit obsolete. So nowadays the argumentative approach is the dominant one, but of course this assumption does not eliminate problems. The contrary is the case, because we have different formal models of argumentation, including the abstract ones and structured ones, and each of them encompasses some like aspects or portions or features of real life argumentation, but these are of course only formal tools. So they have their limitations. This is the first observation. The second observation is that in fact it is very difficult to construct a conclusion from a knowledge base. It's much more simpler to verify an answer once you have it. So if you have an answer, you can check whether it is validated by your knowledge base, whether you can do you can perform a valid inference step. This dialogical reasoning chain from what is available in the knowledge base to the conclusion. But it is a much more ambitious task to write a computer program which could construct the arguments on the basis of the knowledge base itself. So this also leads us to the problems of computational tractability, which are in fact very fundamental problems of the theory of algorithms. And the final observation in this connection would be that in order for these argumentation models to operate, we need to give them the input, we need to give them feed. And due to the fact that they are symbolic reasoning systems, the premises they base on need to be formalized in the first place, which is a very complicated process, very time-consuming, prone to error, also very costly because you need to involve legal experts in this and computer scientists in this process. So there is like a leeway discussed during the preceding 4 years that perhaps we could generate these premises by the application of machine learning models, but then again different problems emerge, namely the problems with explainability of the operation of these algorithms and the quality of the data on which these algorithms are trained, and so on and so forth. Like to quote, there are no free lunches here. we pay the price for the application of whatever solution, but like this price is of a different type. But generally speaking, this is the approach. This is the approach that we are currently investigating, and apparently there seems to be no better option than the model of the justificatory reasoning than via the argumentation models. I hope that this answer like clarifies the most important points with regard to this question. And if I have a chance to speak, I would be very happy to ask a question myself to Professor Pedro Diaz Venâncio. So thank you very much for your excellent talk once again. And like following up on your answer to the preceding question, I would quote, I think it's in the Bible, in the Proverbs, that sometimes words are like swords. This is especially, I would say that this is especially important in the contemporary digital age, when, for instance, defamatory information may be disseminated very, very broadly without any possibility for the injured person to counteract this. In a way, it stays forever, like in a society. So the question is whether this consequentialistic approach, does it has any bearing on the contemporary account of the freedom of expression. So many people are writing about it, but I am very curious about your opinion. Sometimes it goes very far. So for instance, not only certain publication may be prohibited by the state, but also in a private dispute, if there is a risk of this defamation, it is possible to block the publication of certain information, preventing the harm before we have a final judgment. And of course, this litigation may last 2 years, 3 years, 4 years. And after 4 years, perhaps the publication of this information will not be necessary for anyone's interest. So it's very difficult to balance this countering interest. I'm very curious about your opinion.
Well,
Pedro?
thank you very much for your question. Well, let me explain something previously, is that the fact that I defended this broad perspective of freedom of expression, and the fact that I defended that copyright stays as a stronghold over freedom of expression, doesn't mean that all the others fundamental rights should not be protected, like honor, or like the right that every state has to protect some fundamental values. And so I can understand that no freedom has no limits. All freedoms have some sort of limits when they shock with someone else's freedom. So that is inevitable. That's inevitable. I'm not saying the right word. There's something missing in my English here. But and it's very difficult to establish the limit between two freedoms, and that will depend very much on every state. For instance, there are some states that don't have the crime of injury, of defamation. Doesn't exist, the crime, because they say that freedom of speech has no limits. So there are some, but that's not the case of Portugal. But there are some countries that have that perspective. So even the limits for freedom, it depends on the cultural and political environment of each country. You cannot compare what Occidental European thinks about privacy as an Asian country. Asian people have a totally different perspective on privacy, and North American have a totally different perspective of freedom of expression, and I can accept that. But the beauty of copyright is that since it protects the creation all over the world, a creation that is prohibited in Europe can be legal in the United States. And one that is prohibited in the United States can be legal in Europe. And more, one work that is offensive today, perhaps in 20 years will not be offensive and is still protected. So the fact that even if I can accept that in some space, in some period of space of time, this work cannot be published because the harm it will bring is more severe than the freedom of expression itself, that doesn't mean that I should eliminate that work, because perhaps in 20 years, it won't make such much harm. It won't make any harm. And then it can be published. Or it makes harm in Portugal, but it does not make harm in China. Probably in China will be probably anyway, so not a good example. So although it may look like a contradiction, for me is not a contradiction. It means that copyright stands. It goes over time. It goes over political options and ethical options and religion options. They change during times. Perhaps not from one year from another, but from decades they change. And copyright protection preserves the opinion for future or for different spaces. That is the sense which I mean that copyright stands as a stronghold for freedom of expression. I don't know if I answered your question, but that is my main idea. Like I said, I'm still hoping to find more ideas on this. There was recently a fine example in Brazil, because a politician made a music adapted a music from a famous author to criticize his opponent, and he went to court because they said he was violating copyright, and he was absolved because the judge says that being it a satiric work, he was free to use another person's work because it was not a copy. It was a critic, and he was free to make that critic during a political debate, something like that. So that is why I think freedom within copyright is more broad than outside copyright.
Thank you very much, Pedro, for answering the question. Are there any more questions to our speakers? If yes, please do ask them now.
We don't receive any questions at the chat, but if the participants can do any question, the microphones are open.
Well, since I don't hear any questions, and there are also no question on the chat board, so I would like to thank you very much for your presentations. I would like also to ask for your comments, and I believe it's a good time to say that's the end, and so I will now finish our session. Once again, thank you our audience to participate, to listen to our esteemed speakers. Thank you very, very much for being with us. And now I will say goodbye, and I hope that you will enjoy another sessions that will take place in 30 minutes. Thank you very much to all of you. Goodbye. Have a nice Congress.
Thank you very much.
Thank you very much.
Thank you.
Boa tarde. Desculpa entrar assim na nosso congresso, cumprimentar os colegas que estiveram no painel, o professor João e o professor Pedro e os demais colegas da Polônia. Queria dizer todos os participantes que nós vamos voltar no horário do programa. Os próximos painéis começam daqui meia hora, né? No horário, pelo menos em Portugal, começa às 3 da tarde e no horário brasileiro, 4 horas menos. Então, vocês podem descansar e entram depois nos links que vocês receberam por e-mail, ou eu peço à coordenação, a comissão organizadora do Iberojur para colocar os links aqui no chat, e vocês também podem depois já clicar e ficar cada um na sua sala, né? Só acompanhar os painéis, tem 3 painéis em simultâneo, sala A, B e C, com os temas respectivos, e nós continuaremos, então, durante a tarde em Portugal e na Europa, e amanhã aí no Brasil. Um grande abraço e até daqui a pouco.